Hello and welcome back to the Data Privacy Lawyer. My name is Funmi Owolabi and I'm the principal attorney at the firm. Today's review is going to be on a policy related to the use of artificial intelligence. So the first thing I'm going to do is I want to scroll down and take a look at version history. I always review this because the use of artificial intelligence in most organizations is continuing to evolve, whether it is that they are procuring additional artificial intelligence, they are integrating an AI tool into an existing process workflow, and or they are building them in-house. There's lots of different ways that you can roll out artificial intelligence. That's why I take a look at this, because the implications for each different step might have different considerations for an organization depending on the geographies. Now, the thing that caught my eye when I went onto this page was the fact that this university appears to be not just in the United States, but they've also got some type of university in London, and then they also had it in Canada. So we've got some discussion, at least. We know that there's going to be some processing of personal data in London, the United States, and in Canada. Now, the value of that is I talk a lot on my reviews about not knowing geography. Geography is really important from a data protection standpoint because your responsibilities as an organization vary geography to geography. For example, the obligations you have related to the privacy laws are going to be different in the United Kingdom than they are in Canada because there are different privacy laws geography to geography. Something I wanted to make mention of is we've got different states, right? We've got Boston in the US, we've got Charlotte, we've got Portland, and we've got Seattle. So we've also got Silicon Valley, and I want to talk a lot about this one. Silicon Valley is in California. In the United States, we don't have one federal privacy law that is overarching on all of the processing of personal data. It's fragmented in that we look at privacy in the United States on lots of different levels, to include the federal level, the state level. We also look at privacy on an industry level. Let's say you're in the healthcare industry, financial industry, communications industry, etc. The value of having at least the different geographies for this organization is that we can start to put together some pieces about the privacy piece, different considerations in these geographies. And one of the main questions I always ask is, where are you providing your products and services? Now, I don't know everything that the university is doing, but I definitely know that there's going to be students at a university. Lots of universities are diversifying the types of offerings they have outside of the traditional educational institution. I know definitely some in the United States have research facilities, hospitals, etc. So, there's lots of different privacy implications depending on all of the services that are offered by an organization. We know it's a university, we know there's students, and we also know geographies in some instances. The value of knowing that related to the policy is there are artificial intelligence legislations being rolled out in different countries. Now, university, especially in the university I went to, although it was in the United Kingdom, right, we had students all over the world come to our university. So even though we can see these geographies at the bottom, a university traditionally is going to process personal data on a global spectrum. Now, I can't say that for a fact for this organization, but I can say it for my university. We had people all over the world. The policy that has been drafted, let's go back to the date. We've had artificial intelligence legislation roll out in 2025. We're in 2026 now, and there is an anticipation that there's going to be additional artificial intelligence legislation that comes out globally. That is going to impact an organization like a university that processes personal data of students from a global spectrum. Remember, privacy generally flows based on where you are a resident, right? Now, I know that specifically for international students, and this would probably be a discussion amongst universities in general, but I don't know how every university does it. But in the United States, you generally get residency in a state, I think, if you've been living there a year. Now, it might vary geography to geography. If I'm incorrect about that, leave a comment below. But let's say, for example, you attend a university and you're coming from, let's just say, Japan. At that time, even though you are physically located in the United States, your residency is still in Japan, right? So if an organization like a university is going to process your personal data, the rights associated with you as a Japanese student are going to be based on Japanese privacy legislation, which is a consideration that organizations need to factor in. Now, why did I give that long explanation? I gave it because it also has implications related to the use of artificial intelligence. If an AI tool that is offered by an organization is ingesting the personal data of a Japanese student, there are considerations that need to be made on how the artificial intelligence is rolled out and in which geographies it makes sense from a risk-based perspective. So there's a lot of considerations that companies need to take and factor in depending on the products and services that they offer. And I've already mentioned a couple of different factors, like the fact that this is a university, the fact that it has all of these geographies down here, the fact that universities generally process global personal data. So that's also a factor here too. Let's go back to the AI piece. This is a policy, right? And they've put scope. This is very important. I talk about scope in every single review that I do because scope dictates who a document addresses. When we look at the website privacy notices traditionally, the website privacy notice generally, it'll have a scope and it'll say something like, this website privacy notice addresses the processing of personal data we do on the website. That doesn't mean that it addresses the personal data associated with vendors or partners. The scope is very important because it will dictate the provisions that a company places related to a specific document. Now, although this doesn't have privacy in the title, we know that privacy is implicated when it comes to artificial intelligence because of the input and output data that could constitute personal data, and many times it does. I've yet to review an AI system or technology that does not implicate privacy in some respect, whether it's the username and password that's required to log into the tool or the input data that is ingested by the algorithm. So that's why we look at this as privacy counsel. That's why we work in tandem with AI counsel. Now, not every organization has those in-house. Sometimes that's outsourced. But it's very important to be particular given the evolution of the legislation associated with artificial intelligence. One, to know what's happening within your organization, because there's different groups, right? We've got the sales group, we've got the marketing group, we've got the employee group, we've got individuals that work within the university. There's lots of different uses of artificial intelligence in an organization that need to be captured when drafting something like a policy, which is why there's a lot of due diligence and discussions that are done with different stakeholders by the Privacy Council in order to draft these. So I really want us to get to the definitions piece because I had mentioned that although this is not a traditional privacy document, personal data is always implicated. And they've provided a definition which I think is useful. I've talked about this in other reviews too. Definitions are important because of the audience. The audience here is not a privacy lawyer. The audience here is faculty, I'm presuming, and establishing core requirements applicable to Northeastern's use of AI systems in university operations. Anybody that uses AI systems in the university operations and outside professional activities, this policy is for you. And we can see here faculty and staff, both of which are groups of individuals. So let's go back to the definition. I want to talk about why definitions matter for the organization that is issuing the policy, and then also why it matters for the audience. I talked about how there are obligations depending on geography. The definition of personal information is going to mean different things in different geographies. For example, when we look at the European Union, the legislation in the European Union discusses a specific identifier known as a special category of personal data. Now, we don't see special categories of personal data in the US. We see something called sensitive personal data, right? There's both personal data, but the definition varies because of the geography. And something else caught my eye, and it was basically these personal data identifiers. The personal information of students, right? And we can see above, this is an AI system policy. So why are we talking about personal data? And that's why I'm reviewing it on the channel. Because if you're using artificial intelligence within your organization, you need to know that there are privacy considerations you should have that will implicate your privacy program. And we can see they collect health information. Now, I think it's valuable to highlight this because I talked about how a university doesn't just generally provide services for the students in terms of education. It may be that there is a hospital associated with the university too. And we've got parents' information, alumni, employees and contractors. All of these groups are all individuals, and their personal data needs to be protected in the use of an AI system. So we didn't get much into the policy, but I still think the value of talking about definitions is something that should be consistent amongst all of the privacy documentation, and then also documentation that is not traditionally a privacy document. It's not traditionally a privacy document like a privacy policy or a notice, but it does have implications on privacy, which is why it should be reviewed by a counsel. So I really hope you enjoyed this review. If you have comments or questions, leave one below and I'll see you in another review.